Good morning. Good morning, everybody. Namaskar. This is Engineer Suraj Singh speaking from Bharat, India on this day, November 9, 2021, Tuesday, and talk about same quality and safety. The certifications. Quality, safety. Just now I show to you one document which is available on website of Institution of Engineers India. This is regarding opinion pertinent Royal Charter. Royal Charter was granted to Institution of Engineers India in year 1935. Institution of Engineers head office which is located in Kolkata, 8 Gokhale Road. This regarding opinion is obtained in 1958 by Institution of Engineers from Office of Attorney General of India of that time, Mr. M.C. Sethalwad. This is that one. This is, you can say, this is opinion of Mr. M.C. Sethalwad in respect of Royal Charter as granted to Institution of Engineers in year 1935. Summary of opinion. I'll show you charter also, but let's first read what it is. A reference was made in 1958. A reference was made in 1958 to Mr. M.C. Sethalwad, then Attorney General of India, Bharat, requesting for his opinion in respect of following. In respect of following. This is the document. This is the document. You can see body corporate. Every person being at any time a corporate member of institution may, so long as he shall be a corporate member, take or use name or title of Chartered Engineer India. Chartered Engineer India, this is a term specified and included in Royal Charter. So that's what I'm trying to give you opinion about. Now what it says. In India on and after 15th August 47. क्वेश्चन किया गया इंस्टीट्यूशन के द्वारा, आईआई के द्वारा, गवर्नमेंट से, अटॉर्नी जनरल से कि इसका लीगल स्टेटस बताइए रॉयल चार्टर का, जो 1935 में हमें मिला, आईआई को मिला. वेदर इट इज़ नेसेसरी फॉर आईआई टू रिक्वेस्ट इंडियन पार्लियामेंट to enact a special statute granting to IEI status of body corporate. ऑलरेडी बॉडी कॉर्पोरेट है, लेकिन क्या ये आवश्यक है कि दोबारा से गवर्नमेंट को कहा जाए कि स्टैट्यूट बनाए इसके लिए? ये क्वेश्चन किया गया. वेदर amendments of bylaws of IEI are to be ratified by Privy Council or any other authorities in terms of provision of clause 18 of said charter before इम्प्लीमेंटेशन. क्या जो भी बाईलॉज चेंज हो, अमेंड हो, उनको प्रिवी काउंसिल से अप्रूवल लेनी जरूरी है? We got opinion. Mr. Stalwart relied upon provisions of Government of India Act 1935, Indian Independence Act 1947, Abolition of Privy Council Jurisdiction Act 1949. His opinion in short were as follows. Royal Charter granted in year 1935 was a valid written instrument containing a grant by Crown made in form of letters patent with great seal having effect and authority of an act of parliament, and repeal of such a charter is only possible by another act of parliament. This act of granting royal charter had not been repealed by any other act by इंडियन पार्लियामेंट. ये एक्ट है जो एक्ट के द्वारा ही काटा जा सकता है, ऐसा कुछ हुआ नहीं. आईआई continues to be in eyes of law a valid body corporate and politic, notwithstanding constitutional changes in India on or after 1947. इंस्टीट्यूशन बॉडी कॉर्पोरेट है कानून की नज़रों में, अभी तक बॉडी कॉर्पोरेट है और कोई भी इसको डिनाई नहीं कर सकता. बॉडी कॉर्पोरेट एंड पॉलिटिक. What is body corporate? Definition is a county according to court is a body politic and corporate. A body politic is a civil division in state for purposes of government administration. A body corporate is a legal entity. Body corporate and politic legal definition. When applied to government, this phrase signifies that, what do you say? I'll try to show you. I'm going to read it from definition. I'm going to read this definition. Legal definition of body corporate and politic. It says that body politic, it's a government corporations. When applied to government, this phrase signifies state. This phrase signifies state as to persons who compose body politic. They take collectively name of people or nation, and individually they are citizens when considered in relation to their political rights and subjects as being submitted to laws of state. When it refers to corporations, this is what definition of it is. So I'll go to other one for purpose of explanation. What is body corporate? This is another definition. This is from Black's Law Dictionary. It's Black Law Dictionary. It's not allowed. So I'll take another one. It is what? Independent body, that is body corporate. It says that independent public body. Body politic. Body politic is a polity such as city, realm, state, considered metaphorically as a physical body. Historically, sovereign is typically portrayed as a body head, and analogy may also be extended to other anatomical parts as a political readings of are feasible. So that's what I say. Now we'll continue with this. Interpretation is given by, and that is here. Charter granted to II remains in full force after August 15, 1947, and it is also not necessary for II to request Indian Parliament to enact a special statute granting to it status of a body corporate. And further that, since after introduction of Constitution of India, Privy Council does not have authority in terms of clause 18 of charters to allow, disallow any revision of bylaws, and also for reason of Indian Parliament not enacting any law to recognize charter in any other form. Reference to Privy Council or any authority in India in respect of revision of bylaws is not necessary. Text of opinion. Questioner is Institution of Engineers India. This is office address. Section 2(1) of Government of India Act 1935 inter alia provided that all rights, authority and jurisdiction herefor belonging to His Majesty of King Emperor of India, King Emperor of India, which appertain or are incidental to government of territories in India for time being vested in him, or exercisable by His Majesty, except in so far as may be otherwise provided by or under this Act. Thus, notwithstanding enactment of Act, powers of King under prerogative admit unaffected except as otherwise provided by Act. One of the prerogatives of Crown is to issue orders in council and letters patent conferring rights and privileges. Such prerogative is not confined to British Islands but extends to all parts of Commonwealth, as fully in all respects as to England, unless otherwise prescribed by United Kingdom or local enactment. Aylesbury Laws of England, 3rd edition, volume 7, paragraph this. Principal document by means of which Crown carries into effect or makes known its intentions are inter alia, among others, letters patent under Great Seal and charters. Thus, Crown could, after passing of Government of India Act, validly constitute House of Parliament. Essence of this kind on legislation by King in Council without intervention of Parliament is that its original and in no sense delegated. Prerogative of Crown is defined by Riche in his law of constitution as residue of discretionary or arbitrary authority, which at whatever given time is legally left in hands of Crown. In other words, royal prerogative is what is left of original sovereign power of Crown to legislate without authority of House of Parliament. What is the effect of royal charters containing grant by Crown made in form of letters patent with Great Seal? Royal charter is a written instrument containing a grant by Crown made in form of letters patent with Great Seal. An instrument of grant has effect and authority of an act of Parliament, and such a charter can only be repealed by another act of Parliament. It's at pleasure of Crown to grant or withhold a charter of incorporation, but when once granted and accepted, charter is irrevocable. Result then of exercise of royal prerogative granting charter to Querist on 9th September 1935 was that Querist was created a corporation sole by exercise by King of its prerogative power of legislation, which had effect and authority of an Act of Parliament. Charter created in exercise of this prerogative legislative power by King had effect in British India as if it were a statute passed by section of same as otherwise expressly provided in this Act. Law of British India and of several parts thereof existing immediately before appointed day shall so far as applicable and with necessary adaptations continue as law of each of new dominions. Charter was as already pointed out law of British India before 15th August 1947. It continued to be such law with notwithstanding passing of Indian Independence Act by Sairism. Indian legislature constituted by Section 6 and 8 of Independence Act undoubtedly had power to legislate so as to affect law of British India, even though it may have been made by an act of Parliament. However, India's legislature did not exercise such power in regard to Charter of Querist. Charter therefore remained in full force. Constitution of India provided inter alia that subject to other provisions of this Constitution, all law in force in territory of India immediately before commencement of this Constitution shall continue in force therein until altered or repealed or amended by competent legislature or other competent authority. Charter was the date of commencement of constitutional law in force territory of India. It therefore continued in force after enactment of Constitution and still a valid and binding law and not having been repealed by a competent legislature or competent authority. Queries therefore continues, notwithstanding constitutional changes in India to be, in eyes of law, a valid body corporate and politic. Questions have been raised whether Paris needs any fresh recognition of states status government of India. Questions have been raised whether Paris needs fresh recognition of its status from government of India, or whether it's necessary for Paris to request in the Parliament to enact a special statute granting to Paris status of body corporate in view of what has been stated in preceding paragraphs. Courses suggested are unnecessary. Question has been raised in regard to construction of clauses. Charter, in my view, those clauses are wide enough to cover engineering in all its branches, enough branches including civil, mechanical, electrical, telecommunication, chemical, and aeronautical engineering. A difficulty has arisen in regard to clause 18 of Charter, which provides for making revocation, alteration, or amendment of bylaws of Querist. Clause provides that no such bylaw, revocation, alteration, or amendment shall take effect until same has been allowed by Lords of Privy Council, which allowance certificate and head of clerk of our Privy Council shall be conclusive. Hence, it appears that Querist was desirous of revising its then existing bylaws and approves Government of India for its purpose. It appears to have been suggested to Paris that it should approach His Majesty's Privy Council for proposed revision in terms of clause 18. Thereupon Paris approached Privy Council, and towards the end of year 1951, Privy Council permitted revision. Like Paris, revised bylaws for revision of bylaws was incorrect. Notwithstanding provisions of clause 18 of Charter, Privy Council would not have, I think, authority after adoption of Constitution to allow any revision bylaws. Authority which Privy Council had under that clause was possessed by it as a body subordinate to Crown, who could exercise royal prerogative in British India. Authority of Crown having seized Privy Council could not function under that clause of Charter. I have dealt with important questions raised in नहीं उठेगी नहीं Okay, gentlemen, I just explained to you something very important regarding Institution of Engineers India Royal Charter opinion that was passed by Attorney General of India in 1958 on request of Institution of Engineers India in a query. That charter is very as far as the responsibility of engineers are concerned. That was just for information because it's nothing new, it is long back when I was just 3 years old, maybe at that time. But law is law. There has been some confusion among people and among engineers itself, but people do not refer to documents, and that's why problems do appear. My talk regarding daily interactions with people is about quality safety and engineering and otherwise. And this talk is always very limited to quality, which is very widest everywhere. So it is very limited, but it gives wide impact on people of our country as well as other countries. Is seriousness of quality is super serious. I think that if we are not serious about quality, we cannot implement quality because it's difficult always to abide by requirements, and because people are not serious, people are not people do not concentrate, in fact, and that's why there appear lapses in quality achievements. And of course, at many places safety is ignored too, which leads to unexpected accidents or incidents or injuries to human and failure of machines, human and machines both. And if machines result in accidents, costs heavily. So it's a matter of great concern. Nowadays, products are many in market. You buy a product without quality, you will feel upset. That is really and singles are 0 0 means this recording is going to collapse. Is happening again 0 and 2 fps. I don't know really. This is quality of transmission of signals. What do you expect? If these people sleep all time, really I'm how why at night times early morning around 4:30 and maybe there is a rush or no rush, but there should be some quality of signals transmission, and that's why I speak for following standards of quality. If one time now it is 0 0, maybe after 5 seconds it will be 1 MB. That's my question. Why no controls? Now it is 189 kbps and 12 fps. That's what my problem is. My question is, advancement means loss of quality? Is it? You think so? आपको लगता है अगर हम आगे बढ़ रहे हैं तो क्वालिटी गिराते जाएं? ऐसा होना चाहिए? आगे बढ़िए, आगे बढ़िए, आगे चलिए, बहुत कुछ कीजिए, लेकिन सब कुछ पे पानी फेर दीजिए। क्वालिटी नहीं मिलने का मतलब पानी डाल दिया, जो भी था पानी डाल दिया, पानी में सब बह गया। वह कहना है सिर्फ मेरा, वी डील विद लाइफ्स, वी डील विद क्वालिटी, we deal with designs, we deal with construction, we deal with methods, contracts, communication, coordination. As I always stress about coordination and communication, which are very important. इतने सारे काम हैं, इतने सारे एक्टिविटीज़ हैं कंस्ट्रक्शन में, प्रोडक्शन में। चलो प्रोडक्शन तो माना फैक्ट्री का काम है, बहुत कुछ ऑटोमेटिक भी होता है, लेकिन कंस्ट्रक्शन में ऐसा नहीं है। काम तो करना पड़ता है, मैनुअल वर्क ज़्यादा है। जितनी मर्जी मशीन लगा लीजिए आप, ह्यूमन फैक्टर को नहीं हटा सकते। आसान नहीं है। वो काम सही तरीके से करे। अगर वो नहीं करता है सही तरीके से, उसको क्या मिलता है मैंने क्वालिटी के साथ जाएं, कोई प्रॉब्लम नहीं। अगर आप क्वालिटी को गिरा दें और कहीं हम फास्ट जा रहे हैं तो ये ठीक बात नहीं है। क्वालिटी दें, क्वांटिटी भी दें, उसे ही हम इंजीनियरिंग कहते हैं। यू वर्क विथ क्वांटिटी, you work with quality, then say, this is my production that is applicable, that is acceptable. We talk of contracts. Contracts दो व्यक्तियों के बीच का फैसला, हमारे दोनों के बीच में ये रिलेशंस रहेंगे इस प्रोजेक्ट के लिए, ये हमारी टर्म्स एंड कंडीशंस हैं, शर्तें हैं। आपको speak that, and person who is going to do it also cannot speak that. They can neither speak that nor write that. Why should one say, do it bad? Bad is not contract. It is, you can say, carelessness. It is ignorance. It is, I can say, foolishness that we lapse quality system. Nothing is going to be saved. If you think by dropping quality you can save something, then it is another foolishness. Material consumption shall remain same, time shall remain same. Even you have to waste time, if you have to do it again, you not only waste time, you shall waste material also. So I can say nobody will accept this. Nobody. दुनिया में कोई भी नहीं मानेगा टेम्पररी quality is a part of work. We are not serious. It's not only in work, it's in every work, in every field. Even if you work in office, not engineering, you have to give quality. Maybe it's different standard of quality, it's different domain of quality. Its domain is unknown to you probably, but it is required. Problem lies in when people do not have will, or they want automatically it has to happen. Nothing happens professional, low level professional. There's a lot of division of thinking. There's a time when everybody was serious. Now seriousness is not defined. Without seriousness, we cannot move. And again I say, seriousness is not impression based. Face impression, no, it's not face impression. It is work impression. My work should tell. My work should speak its level of seriousness. That work should announce degree of quality, degree of quantity, because without combination of quantity and quality, we cannot say it is production. It is very serious issue. And we talk on commencement, delays and suspension of works done by whatever contractor. Always there are issues. Contract is a system. Even if we do it ourselves as engineers, we say, okay, because you have to buy, you have to procure all resources, you have to procure material, you have to procure human resources, you have to procure mechanical resources. Whatever is to be done, whatever is to be included, that requires to be procured. आप सोचें कि मैं खुद कर लूँगा, मैं इंजीनियर हूँ, मैं स्ट्रगल कर लूँगा, मैं खुद ये काम करूँगा, मैं समझता हूँ इससे अच्छी कोई बात नहीं हो सकती, लेकिन ऐसा होता नहीं है। करके देखेंगे, अच्छा लगेगा कि आप इतने ज़्यादा उत्तरदायित्व रखते हैं, इतने ज़्यादा रिस्पॉन्सिबल हैं कि आप चैलेंज को ले सकते हैं। आई लाइक इट इफ somebody says, don't worry, I'll take care of this job, I will do myself, I don't need a full-fledged contractor, I want just a supportive contractor who can get me human resources, who can get me materials, or if not materials, who can get me support. Some support, I mean to say, because I'm not clear about market, I'm not clear about locations where workers are available, I don't know all sources from where I can buy materials. Likewise, you mean that type of support I require, or I can employ someone for procurement purpose that can help me. Or you can say, you are an engineer, everybody expects you that you can do it, you are qualified for that. That contractor cannot be unknown to that profession. That contractor must have exposure, total exposure. That contractor must be qualified in profession of engineering. Otherwise, On what basis can you give that contract? Either that contractor must have long standing with high class professionals, it's a combination of contract arrangements. That's what contract's all about. It's a kind of commercial entity. And everybody doesn't have money. I'm not going into that. Significant in world of construction and quality. Take that level of struggling profile. It's really real engineering when you do work yourself. But you are habitual now. Without input, without support of contractors, we cannot do it. Well, it's a trend, but do it through contractor, no problem. Even then you don't have any right to abuse quality that is expected on whatever work you do. It's not in formality. You say I've done quality. We're not interested in formality. We are interested in facts. हमें दिखाना नहीं है हमने क्वालिटी ली है, हमें क्वालिटी लेनी है. कागज नहीं पूरे करने हैं, हमें contract system, that is engineering, procurement and construction type of contract, where design is also done by contracting organization, and once design is done and approved by engineer or employer, that is worked upon, that is carried out on projects. And of course, when you contract, your contractor shall work for you, indeed, and that contracting organization cannot be only a shop. It cannot be like malls, but it can be like intellectual group who works in profession. That's what I think it should be. Work is technical, work is engineering, and therefore only such types of contractors should be shortlisted, should be selected. You cannot select a person who knows nothing about profession and one claims that I am contractor. I don't accept such person, because I know you shall spoil me, you shall spoil project, because you do not value quality. Why should I have your services? And I have doubt in you. Young contracts, there are always problems. Not because contract is bad or good. It's not because that. It's because of many other reasons as well. Something is beyond my control, something is beyond your control, and something is within control. When something is within controls, you can control that. We can control that indeed. But point is different here. We are seeing commencement, delays, and suspension. And what is for commencement, what is for delay, and what is for suspension? We are talking of works. Works to commence work, to complete work, or if there are delays, you cannot complete in time, or there may be some other problem that you have to suspend activities due to whatever reason. That's also a point. So it is said that there is always appointment date, there is always no date given in contract. On this day, you have to start maximum on this day. Commencement date says unless commencement date is stated in contract agreement, employer shall give a notice to contractor stating commencement date not less than 14 days before commencement date. Says unless commencement date is stated in contract agreement, employer shall give a notice to contractor stating commencement date not less than 14 days before commencement date, unless otherwise stated in particular conditions. Commencement date shall be within 42 days after date on which contract comes into full force and effect under contract agreement. Contractor shall commence execution of works on or as soon as is reasonably practicable after commencement date, and then proceed with works with due expedition and without delay. As case may be, including completion of all work which is stated in contract as being required for works or section to be considered to be completed for purposes of taking over, that is under taking over works and sections. So time of completion is very important. Contract shall complete whole works in each section if sections is defined within time for completion for works or section as case may be, including completion of all work which is stated in contract as being required for works or section to be considered to be completed for purposes of taking over works. Contractor shall submit an initial program for execution of works to employer within 28 days after receiving notice under subclause commencement of works. This program shall be prepared using programming software stated in employer's requirements, and if not stated, program software acceptable to employer, So these are just conditions for program. Already we have discussed this. Unless otherwise stated in particular condition, contract shall also submit a revised program which accurately reflects actual progress of works. Wherever, whenever program ceases to reflect actual progress or employer suspension. Employer suspension point here. What's that? There are so many issues which we have to consider. We have to consider so many issues, and that is what employer suspension. It says employer means party one on contract. Employer may at any time instruct contractor to suspend progress. Employer may at any time instruct contractor to suspend progress of part of all of works. एम्प्लॉयर में एट एनी टाइम इंस्ट्रक्ट कॉन्ट्रैक्टर. एम्प्लॉयर कभी भी ठेकेदार को इंस्ट्रक्शन दे सकता है कि आप काम को सस्पेंड कीजिए. एम्प्लॉयर में एट एनी टाइम इंस्ट्रक्ट कॉन्ट्रैक्टर टू सस्पेंड प्रोग्रेस ऑफ पार्ट और ऑल ऑफ वर्क्स, which instruction shall state date and cause of suspension. During such suspension, contractor shall protect, store and secure all part or all of works against whatever deterioration, loss or damage. कॉन्ट्रैक्टर के वर्क को सस्पेंड करने के बाद कॉन्ट्रैक्टर की ड्यूटी बनती है कि जो भी काम किया है, जो भी मटेरियल है, उसकी प्रोटेक्शन दे, उसकी परवाह करे, ताकि वो मटेरियल में काम ख़राब ना हो. ख़राब ना हो समय में जब सस्पेंशन है, वो नुकसान ना हो, डैमेज ना हो. टू एक्सटेंड दैट cause of such suspension is responsibility of contractor shall not apply. Means रखना ही पड़ेगा, सही रखना ही पड़ेगा. Consequences of employer suspension and etc. Prolonged suspension, many other clauses are there. We'll go into that. अभी सस्पेंशन का उत्तर क्या है, सस्पेंशन का इफेक्ट क्या है. I repeat first employer suspension so that you can clearly understand. Employer may at any time instruct contractor to suspend progress of part of all of works, which instruction shall state date and cause of suspension. During such suspension, contractor shall protect, store and secure such part of all works against whatever and or incurs cost from complying with an employer's instruction, employer suspension, or from resuming work under resumption of work. Contractor shall be entitled, subject to claims clause, for payment of EOT and or payment of such cost plus profit. If contractor suffers delay, अगर contractor को देर होती है, कॉस्ट लगती है, एम्प्लॉयर्स के इंस्ट्रक्शन के बाद सस्पेंशन, तो दोबारा काम शुरू करने में भी रिजम्पशन ऑफ वर्क, कॉन्ट्रैक्ट को अधिकार होगा कि वो क्लेम्स कर सके पेमेंट का या एक्सटेंशन ऑफ टाइम का, और पेमेंट ऑफ सच कॉस्ट प्लस प्रॉफिट. Contractor shall not be entitled to extension of time or to payment of cost incurred in making good. Consequences of contractor's fault, अगर वो कॉन्ट्रैक्टर की फॉल्ट की वजह से है या गलत डिज़ाइन की वजह से है, डिफेक्टिव डिज़ाइन की वजह से है, या वर्कमैनशिप की वजह से है, या प्लांट और मटेरियल और किसी और वजह से है. Any deterioration, loss or damage caused by contractor's failure to protect, store or secure in accordance with employer's suspension. So what it says, contractor shall not be entitled to extension of time or to payment of cost incurred in making good. Consequences of contractor's fault of defective design, workmanship, plant or materials, and or any deterioration, loss or damage caused by contractor's failure to protect, store or secure in accordance with contractor shall be entitled I think it's in my contractor shall be entitled to payment of value. Contractor shall be entitled to payment of value as at a date of suspension instructed under employer suspension of plant or materials which have not been delivered. Contractor shall be entitled to payment of value on date of suspension, whatever instructed, and whatever plant and materials which have not been delivered to site. जो प्लांट और मटेरियल डिलीवर नहीं हुए हैं लेकिन ऑर्डर हो गए हैं, उसको हक होगा कॉन्ट्रैक्टर को उसकी पेमेंट दी जाए. Says if or materials has been suspended for more than 28 days, work of plant, any machines, work of plant means machines or equipment or delivery of plant and or materials has been suspended for more than 28 days, and plant and or materials were scheduled in accordance with program to have been completed and ready for delivery to site during suspension period. Contractor provides employer with reasonable evidence that plant or materials comply with contract, and contractor has marked plant and or materials as employer's property in accordance with employer's instructions. ये है materials plants का shall be entitled to payment of value of plant and material more than 28 days. And plant and materials were scheduled in accordance with program to have been completed and ready for delivery to site during suspension period. Contractor provides employer with reasonable evidence If suspension under clause employer suspension has continued for more than 84 days, contractor may give a notice to employer requesting permission to proceed. 84 दिन 84 डेज से ज़्यादा हो गए, कोई हो नहीं रहा शुरुआत, कॉन्ट्रैक्टर नोटिस दे सकता है एम्प्लॉयर को कि काम को शुरू करने की परमिशन दी जाए. इस सस्पेंशन अंडर एम्प्लॉयर सस्पेंशन क्लॉज हैज़ कंटिन्यूड. Contractor's notice under this clause, contractor may either, contractor's rights are, contractor may either agree to further suspension, in which case parties may agree for extension of time of cost plus profit, and if contractor incurs cost on that, and or payment for suspended power plant and or materials arising from total period of suspension, or if parties fail to instructed under subclause, variation by instruction with immediate effect, including release from any further obligation to protect, store and secure under employee suspension. If suspension affects whole works, contractor may give notice of termination under termination by contractors. सेकेंड नोटिस देगा, नहीं सुनता तो कॉन्ट्रैक्टर राइट बनता है, एम्प्लॉयर नहीं सुनता कॉन्ट्रैक्टर राइट बनता है टर्मिनेट कर दे कॉन्ट्रैक्ट को. कुछ हिस्सा है टर्मिनेटेड, उसके लिए बोले भाई क्या करना है, इसको ओमिट कर देते हैं, हम इसको अपने स्कोप से बाहर कर देते हैं और जो भी स्टेटस है उसका क्लेम करते हैं. Very significant one, but remember these clauses are not very common in application because suspensions are very rare due to various reasons. Resumption of work. Contractor shall resume work as soon as practicable after receiving a notice from employer to proceed with suspended work. At time stated in this notice, in this contractor receive this notice, contractor and employer shall jointly examine works and plant and materials affected by suspension. Employer shall record whatever deterioration occurs, loss, damage or defect in works of plant or materials which had which has occurred during suspension and provide this record to contractors. Contractors shall promptly make good all such deterioration, loss, damage, or defect, so that works, when completed, shall complete. Contractor's obligations, and that's on test on completion. Test, very important one, which is a part of every project. Testing, though it's given in contract for information, but testing is technical matter, complete technical. It's engineering matter. And what a contract's obligation? We are going to discuss that one. Contractor shall carry out tests on completion in accordance with this clause and subclause testing by contractor. After submitting documents under as-built records and operation and maintenance manuals. Getting some gastric. Contractor shall carry out tests on completion in accordance with this clause, testing by contractor, after submitting documents under as-built records. And subclause contractor shall submit to employer not less than 42 days before date of that contractor intends to commence test on completion. A detailed test program showing intended timing and resources required for these tests. Employer may review proposed test program and may give a notice to contractor stating extent to which it does not comply with contract. Within 14 days after receiving this notice, contractor shall revise test program to rectify such Court shall not commence test on completion until a notice of no objection is given for given or is obtained. If employer gives no such notice in 14 days after receiving test program or revised test program, employer shall be deemed to have given a notice of no objection. Contractor shall not commence test on completion until his notice of no objection is given. on test program. Contractor shall give a notice to employer of not less than 21 days of date after which contractors will be ready to carry out each of tests on completion. Contractor shall commence tests on completion within 14 days after this date or on such day or days as employer shall instruct, and shall proceed in accordance with contractor's test program to which employer has given or is deemed to have given a notice of no objection, unless otherwise stated in employer's requirements. Unless otherwise stated in employer's requirement, test on completion shall be carried out in stages in following sequence. This sequence is pre-commissioning tests on or off-site as appropriate, which include appropriate inspections and dry or cold functional tests to demonstrate that each item of works or section can safely undertake next stage under paragraph B below. First is pre-commissioning test, which is dry cold, then commissioning test. We shall include operational tests specified in employer's requirements to demonstrate that works or section can be operated safely and as specified in employer's requirements under all available conditions. Under available operating conditions, we shall demonstrate that works or section perform reliably and in accordance with contract. Tests of each stage, first is pre-commissioning, then commissioning, and then trial. Test on each stage described above in B and C shall not be commenced until works or section have passed previous stage. During trial operation, when works or sections are operating under stable conditions, contractor shall give a notice to employer that they are ready for any other tests on completion, including performance tests. Performance test shall be carried out to demonstrate whether works or security comply with performance criteria. Criteria specified in employer's requirements and with schedule of taking over under employer's taking over clause. Product produced by and any revenue or other benefit resulting from trial operation under subclause shall be property of employer. What is say? As soon as works or sections having contractor's opinion Past each stage of test on completion described in paragraph submit a certified to report of results of these tests to employer. Employer shall review each such report and may give a notice to contractor stating extent to which results of tests do not comply with contract. If employer does not give such notice within 14 days after receiving results of tests, employer shall be deemed to have given a notice of no objection. In consideration of results of tests on completion, employer shall mark and shall make allowances for effect of use of works by employer on performance or other characteristics of works. Sorry. Delayed tests. If contractor has given a notice under contractor's obligations that works or section are ready for tests on completion, and these tests are unduly delayed by employer's personnel or by a cause for which employer is responsible, interference with tests on completion shall apply. If tests on completion are unduly delayed by contractor, employer may, by giving a notice to contractor, require contractor to carry out tests within 21 days after receiving notice. Contractor shall carry out tests within 21 days after receiving notice. Contractor shall carry out tests on such day or days within this period of 21 days as contractors may fix If tests on completion are unduly delayed by contractor, employer may give a notice to contractor requiring contractor to carry out tests within 21 days after receiving notice. Contractor shall carry out tests on such days or days within period of 21 days as contractor may fix, for which contractor shall give a prior notice to employer. within this period of 21 days after second notice is given by employer to contractor. Employer's personnel may proceed with tests. Contractor may attend and witness these tests. Within 28 days of these tests being completed, employer shall send a copy of test results to contractor. If employer incurs cost, if employer incurs additional cost as if employer incurs additional cost as a result of such testing, employer shall be entitled, subject to claims for payment and EOT, to a payment by contractor of costs reasonably incurred. Whether or not contractor attends these tests on completion shall be deemed to have been carried out in presence of contractor, and results of these tests be accepted as accurate. Retesting. Works or section fail to pass tests on completion. Defects and rejection shall apply. Clause defects and rejection shall apply. Is now retesting. If a works or section fails to pass test on completion, defects and rejection shall apply. Employer or contractor may require these failed tests and tests on completion on any related work. This test shall apply. Says if works or section fail to pass test on completion, defects and rejection shall apply. Employer contractor may require these failed tests and tests on completion on whatever related work be repeated under same terms and conditions. Such repeated tests shall be treated as tests on completion for purpose of this clause. Failure to pass test on completion. If works or section fail to pass tests on completion, repeated or retesting, employer shall be entitled to. What entitlement here? अगर टेस्ट फेल हो जाते हैं तो उसका क्या हक है? If works order further repetition of tests on completion under clause retesting. If works or section fail, if works section fail to pass, if works section fail to pass test on completion, repeated retesting, employer shall be entitled to order for the repetition of tests on completion, reject works if effect of failure is to deprive employer of substantially whole benefit of as provided in subparagraph failure to remedy defects. Reject section if effect of failure is that section cannot be used for its intended purpose under contract, in which event employer shall have same remedy as is provided in failure to remedy defects, or issue of taking over certificate if employer so requests. In event of subparagraph, contract shall then proceed in accordance with all other obligations under contract, and employer shall be entitled to claims for payment and or extension of time to repayment, to payment by contractor, or a reduction in contract price as described under failure to remedy defects respectively. This entitlement shall be without prejudice to any other rights of employer may have under contract or otherwise. Employer taking over. Employer taking over works and sections. Taking over works and sections. Except as stated in subclause, failure to pass test on completion, except as stated in subclause, failure to pass test on completion, taking over of parts of work shall be taken over by employer when submitted under as-built records. If applicable, employer has given or is deemed to have given A notice of no objection to provisional O&M manuals for works submitted, operation and maintenance manuals. If applicable, contractor has carried out training as described in training, and a taking over certificate for works has been issued or is deemed to have been issued. Taking over certificate by giving a notice to employer not more than 14 days before works will, in contract's opinion, be complete and ready for taking over. If works are divided into sections, contractor may similarly apply for a taking over certificate for each section. Remaining works or sections shall not be taken over until conditions described in subparagraph above have been fulfilled. Employer shall, within 28 days after receiving contractor's notice, either issue taking over certificate to a contractor stating dates on which works or section were completed in accordance with contract, except for any minor outstanding work and defects as listed in taking over certificate. It shall not substantially affect safe use of works or sections for intended purpose. Reject application by giving a notice to contractor. Reject application by giving a notice to contractor with reasons. This notice shall specify work required to be done, defects required to be remedied, or documents required to be submitted by contractor to enable taking over certificate to be issued. Contractor shall then complete this work, remedy such defects, and submit such documents before giving a further notice under subclause. If employer does not issue taking over certificate or reject contractor's application within period of 28 days, and if conditions described above have been fulfilled, works or section shall be deemed to have been completed in accordance with contract on 14th day after employer receives contractor's notice of application, and taking over certificate shall be deemed to have been issued. Other than sections shall not be taken over or used by employer except as may be stated in employer's requirements of or as may be agreed by both parties. If contractor is prevented for more than 14 days, either a continuous period or multiple periods which total more than 14 days, from carrying out tests on completion by employer's personnel or by a cause for which employer is responsible, including any performance test that's not possible due to available operating conditions during trial operation. Contractor shall carry out tests on completion Contractor shall carry out testing completion as soon as practicable, and in whatever case before expiry date of relevant defect period. If contractor suffers delay or incurs cost as a result of being so prevented, contractor shall be entitled, subject to subclause, claims for payment and extension of time